Good morning and welcome to today's webinar presentation. We're glad you're here. Our presentation today is what families need to know about planning for a loved one with special needs, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be your moderator for today. We always like to welcome those that are new to our educational webinar series and also thank those that are frequent attendees for coming back. We encourage your general questions today, so please note them in the questions panel on your screen, and we'll pause periodically to address them throughout the presentation. If you have more specific questions, they may be best addressed in a discussion with Steve at a later time. Your questions always add value and they help others learn, so please don't be shy in posing your questions at any time. You also received the presentation slides from me by email yesterday to take notes on them if you wish. These materials are also available in the section marked handouts in the panel on your screen to download at this time. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a couple minutes to fill out this very brief survey and offer us your feedback about the presentation, and we always read and value every comment that you have to share with us. Here at Elville and Associates, we want to be a resource to you and your families and your family for your planning needs. So if you have any planning needs that you need to address, old documents that may need to be reviewed, which is not out of the ordinary, or other planning needs, consider a consultation with Steve after today's presentation. Use today's education that you receive as a jumping off point to get your planning started or revisited. They're a great way to get your specific questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. So welcome again. I'd like to offer Steve from just a very brief introduction before we get started. We're going to have a brief poll to learn who's here with us today and what brought you here, and then we'll get started. So you should be able to see my screen here. We're Elville and Associates. We were founded in 2010 by Stephen Elville here in Columbia. We have several different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, client education, and superior legal technical knowledge. And we do focus on education a lot here at Elville and Associates. We do that in several ways. 1, through our planning processes with our clients. 2, through many educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. We also work every day with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville and Associates. Just a bit about Steve. His work as an attorney for the past 20 plus years, I think 23 to be exact now, has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker and presenter, if you haven't heard Steve speak before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and for a 7th consecutive year. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am very privileged to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children every day, please reach out to me, and I would love to share our story with you when we have just a bit more time. For now, we are going to talk about special needs planning, a very important topic that is near and dear to you, as well as us here at the firm. So to get to know who is here with us today and what's brought you here, we're going to launch a brief poll for just a minute. And that poll is, to get to know our audience, please tell us what has brought you to our webinar today. So I'm going to launch that poll. And if you can make the choice that best suits your situation, we appreciate it. And your choices are, I need to set up planning for a loved one with special needs. Second, I have planning in place, but it needs to be revisited. Third, I'm a financial advisor here to learn to benefit my clients. Welcome to our financial advisors. We appreciate you very much and all you do. And fourth, I'm an interested family member here to gather information. So give it just about 15 seconds here. Hope you have some good plans this weekend. I'm going to my first Orioles game in a long, long time. Very excited tonight. Okay, so we have about 85% of the people here that have cast their choice. 42% say, I need to set up planning for a loved one with special needs. 8% say, I have planning in place, but it needs to be revisited. 4% say, I'm a financial advisor here to learn to better serve my clients. And then 46% say, I'm an interested family member here to gather information. All right, so welcome everybody. I'm gonna close that out. Steve, I'm gonna make you the presenter.
Thank you, Jeff. I can't wait to get started here.
Yeah.
All right, I see that, and I'm going to show my presentation and get my slideshow started, and you can tell me if I'm visible there, Jeff.
Screen looks a little bit cut off there. Let's see
All
here.
right, let's see what I can do.
There we go. It looks good on my end now. Yep.
All right, very good. Well, good morning, everyone, and thank you, Jeff, and happy Friday morning to you. Thank you for being with us this morning. We know you're very busy this August, one of the most exciting months of the summer, and we know you have a lot of plans, a lot of places you could be this morning, but thank you for being here with us to make our webinar series successful. And I want to thank Jeff because he is one of my longtime colleagues and my friend. And Jeff and I, together with his help, we have been able to educate thousands of special needs or families with disabilities, so to speak. And it is an extreme privilege for Elville and Associates to be involved in the special needs planning community. And I am privileged to lead Elville and Associates and all of our attorneys and staff here in our elder law practice and our estate planning practice and in our special needs planning practice, as well as other practices. So thank you again. And my job here this morning is to really bring you into my world of what I see and what I know intuitively that you need to know about special needs planning. And I so much appreciate the mix of people and attendees we have here this morning. Those of you who are in search of doing your planning for the first time, those of you who have planning in place, those of you who are interested family members, and those of you who are financial advisors and CPAs and insurance professionals, and all of you who are what we call part of the collaborative team for families. Thank you all for being here. And I want to assure you of something that as we go through all of this information today, I think, Jeff, we have 56 slides. So we have a lot to cover, but we're going to leave time for questions. We're going to leave time for introspection. I want you to have a tablet or a piece of paper available so that you can jot down notes. Jeff will provide the presentation to you if you don't already have it, along with some ancillary materials we want you to have. But beyond this, and the fact that I want you to walk away with substantive information today, something that you can really grasp, something that you can use and think about and benefit from, I want you to know that many times, I believe families with loved ones with disabilities, they are so busy, they don't have time to address some of the issues we're going to talk about today. A collaborative team, how to properly structure a special needs trust, how to understand public benefits, and all the things we're going to talk about. But I want to assure you that with the proper methodical approach, you can do these things. You can achieve your goals. You can be creative, which may sound strange, but you can be creative in the special needs planning process, and you can become educated. And that's what we are here to do. We believe that if you are educated and you have an advisory team to help you, that you can achieve your goals. So I just want to assure you of these things as we get ready to get started. So thank you for being here, and you are in the right place at the right time if you would like to be educated and understand how to move forward to accomplish your goals in special needs planning. All right, with that said, we are meeting virtually here. This is not technically legal advice, and you can't take it as such because this is meant for education at a very high level. But with that said, I'm going to be bringing you many substantive concepts that you will be able to use, and we will address your questions as much as we can during the presentation. Jeff is an expert moderator. He understands how to interrupt me and how to tell me there are questions, but we will also stop at strategic points to take questions from you, and we will leave time at the end for questions. So just know that your questions will be answered to the greatest degree that we can, and we will move forward now with the presentation. So every one of you has a special situation, and you have a unique family situation. So what is planning? What is special needs planning or planning for a loved one with disabilities? Well, depending on what your situation is, this is about enhancing your loved one's life. It's really about that. And in my opinion, you are building a world. Now let's talk about that. So there is a world right now of public benefits, or what we would call means-tested support or means-tested benefits. And many of you, your loved one is already experiencing this or receiving these types of benefits, or they will receive these benefits in the future. So that is the world of what I will just call public benefits. Special needs planning, or supplemental needs planning, as we'll talk about, is really about building a secondary world, in my opinion, that secondary world of support that will be there for your loved one, and you can articulate what this support is going to look like. And to whatever degree you are able, with the advice of your team, you'll be able to fund that support. So it's about maximizing the potential of our loved one. It's about improving the quality of their lives without restricting them. And it's about building this world that I'm talking about, a secondary world of support. And of course, it's going to be specific to you and your particular goals for your loved one. So as you can imagine, there are many benefits of planning. These could be providing financial security. We're going to be talking about that. We're going to be talking about not only leveraging public benefits, but understanding them. And many people do not understand them, and that's one of the big challenges. Many attorneys don't understand them. Many advisors don't understand them, and this is a hurdle that we must get over. Speaking of advisors, we want to have a lifetime management team. We want to be able to choose a financial advisor, to know that CPAs are a big resource, to know that life insurance is one of the big issues in special needs planning for certain people. So we want to have this team, and we'll talk about that further. Housing is a big issue, and I know for many of you this is near and dear to your hearts. How will my loved one live in the future, and where will they live, and how will the housing be provided? Maybe perhaps right now in 2023, one of the biggest issues we have in special needs planning is, how are we going to provide for ongoing advocacy? How are we going to plan for someone to support my loved one in the future? And that kind of goes into the next bullet point of caregiving needs and coordination with an entire family, depending on what your family makeup is. Many of you have families where there is unquestionable support for your loved one with disabilities. Others of you may have families where siblings are not as supportive, or they're a bit disconnected, and we want to address those kinds of issues. We want to protect loved ones from creditors and predators and being vulnerable to others. And I know that's a big issue that we address. And for some of you, the preservation of assets for heirs all other than your disabled loved one. So this is a way of planning where we hope for the best and we're planning for the best, but with proper planning, many times, and I will say most of the time, we can preserve assets for others depending on how funds come to our loved one and how well you may plan now during your lifetime for your loved one. So successful planning includes the following things, and I think that you will immediately see that I'm being redundant. I am saying things more than once. I'm hopefully saying them in different ways. Jeff likes to tell me that I am intentionally redundant. So we hope that is not a negative thing for you this morning. We hope it's a positive to drive home some of these key points. So having the right team of advisors, we strongly recommend this. My experience is that many families with a loved one with special needs, they do not have these types of advisors, or they don't have a suitable advisor, okay? We want to help you with that. Making sure that we're planning for flexibility. We're going to talk about that big issue today. We're living in a changing world, a very, very diverse world, and politically, socially, legally. Again, the advisory team is not just the one or two or three advisors, but making sure that those advisors are actually communicating with one another. This is something we want to facilitate. Advocates, we talk about advocacy, we talk about ongoing support, and going back to the issue of trust protectors, or flexibility, I should say, I wanted to bring up the issue of what I will call a trust protector. A trust protector is a special fiduciary we're going to learn about that could be a key player for you in the future to make sure that your plan does not go into the future for your loved one with disabilities without any flexibility. So we want to address these things. So let's talk about creating this plan. Well, we want to use our creativity. And I know in special needs planning, we don't talk about creativity very much, but I want to challenge you this morning to take the time to think. Just about the time COVID started, Jeff and I had given so many workshops, and our attorneys had given so many workshops, that we kind of came to the conclusion that one of the biggest things we can do here at Elville and Associates is really give clients time to think, to give you space, to give you the resources that you may need to really consider issues. And those may include, just like we mentioned earlier, where will my loved one live? What type of care will be required? Does my loved one need a conservator, meaning a guardian of the property or a guardian of his or her person? And we also want to talk about alternatives to guardianship. Who else will be involved in this? What kind of lifestyle, what kind of budget do I need to be thinking about? What are the possible challenges in the future that I could possibly address? How do I build layers of protection and not just a kind of a one-dimensional plan? And I think as this process of thinking goes on, we want to develop what is our purpose. All planning should be goal-driven, G-O-A-L, goal-driven. Once we understand our goal clearly and the various aspects of our goal, we can move forward from point A to point B, whether it's special needs planning, whether it's financial planning, or otherwise. Now, one of the things that I'm going to throw out at you today, and we will be very happy to provide this tool to you, is a memorandum of intent. Now, if you and I were sitting in a large room and we looked at trusts of all kinds, special needs trusts, general needs trusts, millions of trusts out there, 98% of them have no letter of wishes, which is kind of a personal guide to the trust that is an attachment. But in special needs, we may call that a memorandum of intent, a special needs memorandum of intent. So if you have a special needs trust for your loved one, but it has no memorandum of intent, well, that's okay. But it would be much better to have a memorandum. And by the way, this takes a lot of work and commitment on your part. But imagine that your loved one in the future has a trustee. And hopefully that trustee is going to be the same person or persons that you articulated. But we are living in a very, very challenging world. And what if the trustees you pick either are not living, or they're incapacitated, or they just refuse to serve, which is pretty scary. And I don't mean to be alarmist this morning. Well, this memorandum of intent would really tell the world, tell a interested or independent trustee in that circumstance about your loved one, would tell them about your goals and expectations and what is my loved one all about? What is his or her health situation? Who are the physicians? Who are the family members? What are their eccentricities and so forth? Arguably speaking, this may be the most important tool that you can use in special needs planning. So I want you to think in terms of not just having a special needs plan and having a special needs trust, but I want you to think in terms of customizing that. This is where I'm talking about being creative and actually telling the world anything that you want the world to know, meaning the trustees in the future, the fiduciaries in the future, the people who may deal with this trust. What do you want them to know about your loved one? And in that way, the trust is specific and it's personal to you and your loved one. Okay, I'm going to continue now, but I'm going to shift gears a little bit now to the financial side. So having worked in the special needs community and elder law and estate planning community for years, we work with clients of all kinds, wealthy clients, not so wealthy clients, grandparents of children with special needs or grandchildren with special needs, parents, relatives. Many of you today on this webinar are relatives. And no one is in the same financial situation. So we want to, in the context of special needs planning, really look at expenses in the future. We want to use the resources of financial advisory firms and financial advisors. I strongly urge you to do this. And this is one of the biggest things, perhaps, that Elville and Associates that we could do, because we are not financial advisors, we are attorneys, but we can help connect you or help you become familiar with financial advisors. Many people either don't have a financial advisor or they don't use the resources and the tools that are available through financial advisory firms to do projections and to be advised through financial plans, or even using CPAs for tax advice and projections. So I want to strongly encourage you to start thinking about, how will I fund a special needs trust or a special needs plan in the future, and use the resources of advisors. Here's an old school expense spreadsheet, and many of you can find things that are even better than this on the internet today, or use your financial advisor's resources to start budgeting, or we can certainly develop a spreadsheet for you here at Elville and Associates. But the idea here is to not have our heads in the sand. The idea here is, yes, this is a lot to think about. This is a hurdle. This is a little bit of a mountain to climb, to even think about this kind of planning, let alone the financial aspects of the planning. But remember that a special needs trust that we're going to talk about eventually here, and the special needs concept, planning concept, as it relates to your overall estate plan. And we realize that many of you have neurotypical or children that have general needs that are not special needs individuals. So this resource planning and this financial planning is really an integral part of estate and special needs planning. So here's an example. You create the best special needs trust in the world, you create the best estate plan in the world. But if your assets do not flow properly, or you haven't provided for the proper fuel, so to speak, to fuel the plan, then the plan will not work as intended. So the alignment of assets, the consideration of assets, the consideration of life insurance is a critical thing. And why would I say that? Well, when you think about it, not only do I know as an estate planner that this is maybe the biggest issue in estate planning and special needs planning is the flow of assets and the funding of assets into a plan. But the truth is that none of us know when we are going to pass away, and none of us know how much money we will have at the time of our deaths. When we consider long-term care costs, all of the challenges of today's world. So good special needs planning is really thinking about these resources, not only now, but in the future. How can I guarantee, so to speak, that I will be able to fund this special needs plan in the future? So this cannot be overstated. Okay, I am going to continue to shift gears throughout the presentation. It is a bit of a wild ride, and I thank you for just kind of riding along with me. We're going to shift now into planning for incapacity. This is part of planning for your loved one. And we want to determine, as part of good special needs planning, even though if we are representing you as parents or relatives of the loved one with disabilities, you are the client. However, we want to, as much as possible in good special needs planning, consider what will happen with our disabled loved one and their right of self-determination, their capacity or incapacity, and how should that be dealt with? Well, in a very simple way of looking at it, I want you to imagine a line, and I want you to imagine this horizontal line from left to right. And on your, if you're seeing me, probably from your right to left, but if you're using your own hands and your own piece of paper or tablet, I want you to think in terms of left to right. On this left side, I want you to consider whether your loved one has the legal capacity in your mind, in your view, to be able to execute powers of attorney and advance medical directives. Now, if they have that mental capacity, that legal capacity, then we want them, generally speaking, to, because they are their own person, they can sign advance directives, powers of attorney. That means that they are waiving HIPAA. They are probably going to appoint you as their healthcare agents. You can make their decisions and you can make their financial decisions, and you don't need a guardianship. You do not need a guardianship because the fact that they have appointed you as their agents is a substitute for guardianship. Now, on that horizontal line, I want you to imagine on the right-hand side, we have guardianship. So we've gone from no loss of rights to guardianship. Does our loved one need an adult guardianship? Not a guardianship of a minor child, but after they're 18, do they need an adult guardianship? And many of you have guardianship for your child or loved one. But that's the question when we're doing special needs planning. And if there is a guardianship in place, or we think there's a potential for guardianship, in the planning itself, we're going to want to designate potential guardians in the will, which is possibly part of the planning. But back to our horizontal line, we have no loss of rights, and over here in guardianship, we have the complete loss of rights. So this is a person who is vulnerable. So we want to really think through that. Now, for those of you who have been following Elville and Associates in our webinars, you know that we are big proponents of the new law, or at least proponents in the sense of educating our clients about the new supported decision-making law. And as part of this horizontal line, I'm going to come back to the middle now, between the two extremes, and we have supported decision-making. And what we are going to do as part of our discussion of special needs planning is determine, does our loved one have this mental capacity? Are they in the middle? They're in that middle ground where they probably could appoint a supported decision maker. Now, this is a subject in and of itself that's beyond today's discussion, and it's a subject that has various viewpoints. And we are not going to be able to get into that today, but good planning for a loved one's incapacity planning is to determine whether they want to and whether they have the ability to appoint a supported decision maker. And there is no loss of rights there either. So there's no loss of rights here. There's no loss of rights here. And one interesting thing is in guardianship in Maryland, a person can be under guardianship, the complete loss of rights, but now under the new law since the fall of 2022, that person can appoint a supported decision maker even under guardianship. So I strongly recommend that you read about supported decision making. And if you're interested in reading my particular article about it, which we've enjoyed a lot of exposure, mostly because of the fact that I'm covering the Maryland legislation in that article, Jeff is happy to send that article to you as well. So this is a key thing. I'm going to move away from the subject now, but I want you to just understand that this is a good thing and an essential element, in my view, of special needs planning. Jeff, I've been going for about 25 minutes, and I wanted just to see if there are any questions you want me to address before I go into public benefits.
Thanks, Steve. No questions as of yet. To our attendees, certainly feel free to pose your questions at any time.
All right, thank you. I think we've got a lot of good students out there, Jeff, and they're just diligent and not thinking about any questions yet. All right, let's talk about public benefits. And I just want to talk about this as a critical element, not only for you as a person who might be revisiting your planning or putting your special needs planning into place initially. It's critical that your trustee, whoever that may be, understand what I will call public benefits. Let's look at public benefits at a glance. One of the most important things I could convey to you today is this simple chart. And I'm going from left to right. Let's start there. Supplemental security income is a means-tested program. Many of you on this webinar this morning, your loved one receives SSI, supplemental security income, and as a result, they receive Medicaid. Maryland calls this medical assistance. So this is the quintessential definition of disability in special needs planning. It's essential, even though it's not very much money, as we know. It's $914 a month right now. And we just want to be aware that this is really critical to understand this element, because the means tested amount, as we know, is $2,000. So if your loved one has a dollar more than $2,000, they will be not eligible, as of the first of a month. So they will be disqualified as of the first of the month. And many of you have struggled with this. So we want to understand that is the quintessential means tested program. Now, as we go into the second column here, we are looking at sometimes a transition between SSI and SSDI. We're going to see on a future slide that someone who is disabled prior to age 22, this is very difficult to grasp on a webinar if you've never heard this before, someone who is receiving SSI because they are disabled. Now, by the way, there are some people, some children who receive SSI when they are not 18 yet. These people, these young people live in impoverished households. Sometimes, for various reasons, someone will receive SSI, but most of the time it's after age 18. So now imagine someone is disabled prior to age 22. They were receiving SSI at age 18, but now they're age 27, let's say, and their parent has either retired or they have died. That person will now move into this middle category, and they will receive Social Security based on their parents' work record. Social Security based on their parents' work record, not on their work record, and that is if they do not have a work record of their own. That person will receive Medicaid, medical assistance, and Medicare. They will automatically get Medicare after a certain period of time. This person is a majority of a lot of special needs individuals who are adults when their parents have either died or retired and they were disabled prior to age 22. Now, let's say that this person has a work record. Many disabled people have a work record and they were not disabled prior to age 22. Well, now, to make a long story a short story, that person will receive SSDI on their own work record and not their parents' work record. And that person will also receive Medicare because they are receiving Social Security disability. And in both of those instances, when I mentioned medical assistance, in both of those instances, we are dealing with someone who is getting all three of those if they are on means tested benefits. So this person on the left-hand side here in the SSI category, they need a special needs trust traditionally as a protection so that the assets that are left to them are not going to disqualify them from public benefits. The person in the middle category here also will need a special needs trust if they are vulnerable or they were to lose their means tested benefits. And that's the thing I want you to take away from this. The person in the middle here, this person who is receiving benefits based on their parents' work record, okay, or their own, could still be in a means tested program. So we still need the special needs planning for the majority of these individuals. And as we're going to see on a future slide, the person who is the disabled adult child who is receiving benefits based on their parents' work record will get 50% of the parent's amount, not the parent's actual amount, but an amount equal to 50%, and they will receive 75% of that amount at death of the parent. So this is something that some of you on this call this morning do not understand or have never heard, and I'm hoping that is going to be something that gives you peace of mind as you think about planning and the future. That is a good thing. On the right-hand side, we have Section 8 or HUD benefits and veterans benefits. I'm just going to briefly cover this. HUD is a program, of course, that provides housing, and many people with disabilities live in HUD housing. HUD housing poses special challenges for special needs planning, and the HUD rules are changing in this year, in 2023. Many of us are scrambling to understand the new HUD rules, but let's just say that using an ABLE account, which we're going to talk about at the end, an Achieving a Better Life Experience account, using that account is a good way to deal with HUD as far as housing goes and how HUD relates to special needs planning. So this is the basis of starting to understand public benefits. Jeff, I'm going to just take a second here to explain to our listeners and viewers that I would recommend that they pick up a book on special needs planning. One of the books that I would recommend is a book written by a gentleman named Kevin Urbash. And my relationship with Kevin Urbash is that I knew him or know him as the past chair of the Academy of Special Needs Planners. He's out of San Francisco, and he wrote a book called How to Administer the California Special Needs Trust. Now, we don't live in California, although we have a California, Maryland, for those of you who didn't know that. But nonetheless, I still would recommend this book, although there are many books out there, because Kevin Urbash does a great job of explaining public benefits. And of course, when you read that book, you'll see that California calls its medical assistance program Medi-Cal, and the benefits and the viewpoints or the explanations are very, very pertinent and very applicable. Also, I would recommend that your trustees or potential trustees read this book. And again, that's just a resource. Kevin Urbash, you are Batsch, Kevin Urbash. And again, there are other resources out there on special needs planning, but I recommend that book in particular. Supplemental security income, a person has to meet certain tests. We are not going to spend a lot of time on this morning. If you need assistance or guidance about SSI or SSDI, please let us know and we will point you in the right direction. But please use this as a guide and for information for your under advisement. This talks about substantial gainful activity and what happens if a person makes too much money. They will be deemed to not be disabled in many cases. The SSI resource test, as I mentioned, is $2,000. Many people don't understand that an SSI recipient can still own a home. Now, that may or may not be a good idea, but they can own a home. They can own an automobile, may or may not be a good idea. And they can also own all of these tangible items and a certain type or certain amount of life insurance and a burial plot and so forth. But they can own these things and not be ineligible for SSI. So SSI is the most restrictive, it's the most restrictive standard. And even then, a person could own these things. Although most of the time, a home or an automobile might be owned in a special needs trust. SSI pays for food and shelter. Right now, the benefit is $914 a month. In some states, there is a supplement. We know this is not very much money. You may be interested to know, however, that depending on how much you're going to leave to your loved one in a special needs trust, unless that amount is very large, unless that amount in general is more than $2.5 to $3 million, the SSI benefit, even though it is not that much, even though it doesn't seem like much, that SSI benefit statistically is extremely important because most people have special needs trusts that are not that great in that amount. And again, my point here is to simply say that the SSI benefit is very important, even though it does not seem to be a lot of money. As we understand public benefits, we need to understand the concepts of earned and unearned income, and we need to understand how our loved one on SSI could lose their SSI and in essence lose their medical assistance because they've earned too much money by earned or unearned income. So we just want to read and understand this concept, which is a little bit beyond today's discussion, but this is basic information for you. And many of you have experienced having a reduction in your loved one's SSI because you are providing in-kind support and maintenance. So remember, SSI is for food and shelter, but if you are living with your loved one is living with you and you're providing food and shelter, you are in essence providing the same thing that SSI is providing. So the maximum amount that they can reduce the benefit is 1/3. Now we're not upset about that so much because that's not going to cause us to lose our benefit most of the time. Sometimes a child could be making some money that reduces their SSI, and then the reduction for in-kind support and maintenance could cause the loss of the SSI and the medical assistance. So we want to be cognizant of this, but in most cases, there are ways around this where your child can pay for, or your loved one can pay for their maintenance, their food and shelter, I should say, and you will not lose the 1/3. So this is something that many people are aware of and some people aren't. So please ask us how to deal with that if you don't know how. The SSDI eligibility test is beyond today's discussion, but again, these are tests for disability, and these slides are for your information. The disabled adult child benefit that I mentioned a few slides ago, this illustrates that. So the person who is disabled prior to 22, that person is eligible for, and if that person is eligible on their parents' work record, which they would be if they don't have their own work record, this person is entitled to future benefits that I believe give many of you who have a loved one with disabilities peace of mind. Medicaid and Medicare, these are some specific slides about things that are covered that we won't have time or we won't have the ability to focus on today, but I'm including these for your benefit, including more slides about Section 8, which is the HUD housing. And remember that HUD poses special challenges that we want to be able to deal with, and there's not many ways of dealing with them. For example, a distribution from a special needs trust to a person who is living in HUD housing traditionally is seen by HUD as an increase in the person's income. It's seen as something that will increase their rent. So if we're dealing with HUD housing, we have to be very careful. And one of the ways of dealing with that is to make distributions from an ABLE account. Housing, I mentioned, is really a concern for many of you. So good special needs planning is the time to think, the time to structure, the time to think through where your child or loved one will live, whether a piece of real estate or residence will go into the special needs trust and be owned by that trust, whether a condo or another piece of real estate would be inside of the special needs trust during the lifetime of the grantors of the trust, or whether the child cannot live on their own and will have to rely on group housing or supported housing in some way. All right, I'm going to keep going now to the part 3 of our presentation. Jeff, I think we're doing fairly well on time. If there are questions, please let me know. Otherwise, I'm just going to keep going into the special needs part, the special needs trust part of the presentation. Many of you on the webinar this morning have been waiting for this particular part, which is we're finally getting to a description of special needs trusts. So I want to take just a few minutes to focus on this chart to kind of establish the foundation of special needs planning in your minds. For those of you who already have planning, I want you to kind of juxtapose this information with your current set of understanding or your original understanding of what you have. I want to take just maybe a few seconds to say, for those of you who do have special needs trusts, I have seen so many different types of trusts that are purported to be special needs trust or supplemental needs trusts. They come in different styles. They come in different levels of understanding of the person or style of the person who drafted them. So I encourage you that we should review your existing trust and just see what you have and really compare that to the contemporary approach. But whoever you are on this webinar this morning, take this information as kind of a kind of a inceptional conceptual approach. The third party trust, as we look from left to right, is really the bread and butter of special needs planning. This is what most of you on this webinar this morning who have trusts already in place, this is what you probably have. The third party trust basically says this: if I'm a parent or grandparent or relative or any third party, I can leave money into a discretionary trust, not a support trust, but a discretionary trust for my loved one. And if I leave that money into that trust and that trust is drafted a certain way, that trust will not be considered to be an available resource for that loved one. So anyone can fund this trust except the beneficiary. This cannot be the beneficiary's money. Anyone except the beneficiary themselves can establish the trust. And notice on the right-hand side, I said earlier that some of you will be concerned about this and some of you will not be. Most people are, but God forbid that your loved one with disabilities were to die. At the time of their death, any remaining money in the trust can go to whoever the grantor wishes, meaning other children, other beneficiaries. And now, because of IRS rules that have been relaxed, a family can leave money to charity without having any negative impact on the retirement plan assets that they've left to a loved one with disabilities. So the third party trust right there at the top, left to right, this is the primary tool that you are going to be thinking about. Now in the middle there, you'll see what I will call a first party trust. And in the bottom part there, we see a pooled trust. So the D4A trust and the D4C trust are what we call first party trust. What do I mean by that? These are trusts where the loved one with disabilities has received money. They received an inheritance, or they were injured, God forbid, in a train accident or a birth injury or some type of car accident, and they've received a lot of funds, or they've received little funds from, let's say, a small inheritance, whatever it may be. This person can, if they are under age 65, as we read left to right, this person can fund a first party trust. Now, the trade-off is, if you look to the right, this is a payback trust. This is a trust that at that person's passing, if there are benefits that have been paid for by the state of Maryland or any other state, it must be paid back to the state, and then anything remaining can go to other beneficiaries. So this is a payback trust. It can be established by a parent, grandparent, guardian, a court, or under the Obama administration's new rule, the new law, the disabled beneficiary themselves, if they are high functioning as an individual and have the mental capacity to do so. So in 42 USC, the United States Code, 42 USC, 1396P, for those of you who like to look up such things, 1396P D4A, that's where this law stems from, and D4C, a pooled trust is a nonprofit organization that if we are over 65 and the person cannot use a D4A trust or for other reasons prefers to use a pooled trust, this kind of thing is available, such as the Arc of Northern Virginia and other pooled trusts in and around the state of Maryland. This is also a payback trust in most circumstances. So this is kind of the foundational slide that I wanted to show you, and I'm going to now be redundant intentionally as we go through these further slides. So a third-party special needs trust, or what we might call a supplemental needs trust, is the best way of providing for a loved one as part of traditional estate planning or traditional special needs planning. It's called a third-party trust again because it is a third person, a third party, that is leaving non-retirement assets such as cash or investments, CDs, or leaving life insurance directly to that trust, or leaving retirement plan assets such as IRAs or 401ks or 403bs to a special needs trust. Now we're going to slow down for just a second. I'm going to take a sip of water. Jeff, interrupt me if there are any questions.
Thanks, Steve. We do have a question. It's circling back to the benefits discussion. Would you like to address that now or wait till the end of the
Thank you.
special needs
That's
trust
fine.
discussion?
Yeah,
Okay.
let's take a break here and answer that.
Okay, it's a little bit specific, so we'll see where we can go with this. It says my son has been disabled since birth and has been on SSI since 18, has never worked. Both his mother and I have recently retired. Will the Social Security Administration contact us about changing him from SSI to SSDI, since it would be more than $914 a month, or should we contact them to make this change? If he does change to SSDI on our work records, is he still restricted to the $2,000 limit? And is that new amount still restricted to expenses for his personal care and benefits?
Well, thank you for that question. And I want to say, well, not knowing all the facts of when you retired and so forth, I would be proactive. If you haven't heard or seen anything from Social Security and no changes in your child's paperwork or benefit statement, I would be proactive. I would go ahead and tell them. Uh, and my assumption is when you say you're retired that you are taking Social Security. So one of the reasons you may not have heard anything is maybe you retired and you have not taken Social Security. So when I say retire, what I mean is one of you is at least taking Social Security. Maybe you've retired but have not yet decided to take it. So that's one issue. And then the $2,000 limit will not apply with regard to the Social Security because your child is a disabled adult child, disabled prior to age 22. However, if your child is on means tested benefits other than the former SSI benefits that they're on, now that is still going to be a concern. That $2,000 asset limit is going to apply to waiver type benefits and other truly means tested benefits such as waiver programs. So that's my best answer for you this morning. And I would kind of take that in relation to when will you be taking Social Security? Now, if you have taken Social Security already and you still haven't heard from Social Security about your child changing over to the disabled adult child status, I would definitely be proactive. So thank you for asking that. Excellent question, Jeff. Thank you. All right, so let's move on now to other arrangements. So we've talked about kind of the quintessential perfect way of doing planning for a loved one with disabilities through a third-party supplemental needs trust, or as we keep in mind as parents and relatives, we're not going to get, extremely upset if somehow, I mean, it's not good, but if somehow our child ends up receiving funds from a relative with good intentions, but that relative didn't listen to you. Hopefully they will once you establish planning. But this money came to your child. We know that one way or the other, we can deal with that situation and get that money out of the child's name so that their benefits are not lost and the benefits can still be protected in a first party trust. All right, now let's talk about other arrangements. Now, believe it or not, people do these things, and I hope you won't do these, but I actually have seen examples of this just recently. So you pass away and you leave an outright inheritance to your child or loved one with disabilities. This results in a loss of SSI and Medicaid or loss of means tested benefits. We don't want to do this outright distribution. Many people ultimately receive funds they should not receive. And now what do we know from this webinar? Those funds can be placed in a first party trust. They're protected. I spoke to someone yesterday by telephone whose child is receiving an inheritance outright from a deceased parent. That's going to potentially cause the loss of benefits unless we get those assets into a first party trust, which we will be able to do. So do not lose faith. Your child or loved one will not lose their benefits. However, this is not the best way to plan because there will be a payback and there is this jumping through hoops to make sure that that situation is fixed. Bullet point number 2, the funds are left in a non-qualifying trust. That's why I mentioned just a few minutes ago, many of you who have plans, we should look at those plans carefully to review them because we want to make sure those trusts are properly drafted. I do see many special needs trusts, not a majority, but I do see quite a few who are either weakly drafted, or they're incorrectly drafted. So we don't want anything approaching a trust that would be non-qualifying. What do I mean by that? Well, A special needs trust is a discretionary trust under the Maryland Discretionary Trust Act. A special needs trust by its very nature is a discretionary trust, and it's not an available resource. A general needs trust, to make it simple, would be a trust for someone who is healthy and well, neurotypical, for health, education, maintenance, and support. Maintenance and support tells us what? This is a support trust. So a support trust would cause the loss of benefits for a loved one with special needs. A discretionary trust, properly drafted, would not. So that's what I'm talking about here. When we leave assets to a non-qualifying trust, that will disqualify that beneficiary and make all of the assets an available resource to them. So we don't want that. If that is the case, that can be fixed through modern techniques, but just be aware that that does exist. Now, some people say, well, and I haven't seen this a lot, except I did see it a couple of times recently, I'm just going to leave assets to another child. My loved one with disabilities, they can't handle money. I'm just going to leave this to another child of mine, and they will take care of my loved one with disabilities. Well, let's look at what the problems are with that. Well, someone dies, leaves assets to brothers or sisters. Well, those assets could be lost to the claims of creditors of the brother or sister. That person might die with ownership of the assets, and whether they intended or not to do it, those assets could flow to someone who is completely unintended by you in a much, much further place away from the beneficiary where they lose access to the money. The loved one, as I mentioned earlier, you might be in a family where you have strong commitment, or you might be in a family where the siblings are not strongly committed. And that sibling may choose in the future not to take care of their brother or sister who has special needs. And lastly, this money could be lost to a divorce proceeding. It could be lost to a tax lien by Uncle Sam. These are just techniques we do not want to use. And I know most of you on this webinar this morning getting educated here would not do this kind of thing. But I want to point out to you the danger of this type of approach. So back to the third-party trust again. This is a trust where the beneficiary didn't create it, the beneficiary did not fund the trust, and the beneficiary is not the trustee of the trust. This is the preferred method. There's no payback requirement. It can be very flexible. It can actually be revocable, where it can be changed during your lifetime, or it could be irrevocable, depending on what the situation is and how much money is being funded into the trust during your lifetime. And it can be very flexible as far as its drafting. Trustee selection is incredibly important, especially in special needs planning, but in the big scheme of things today, in estate planning, it's extremely important. So we do a workshop on trustee selection. Jeff is happy to take information from you and make sure you get our trustee selection workshop. The nuances of trustee selection really surround, well, should a family member be trustee of my special needs trust versus a professional, versus what kind of attorney or CPA involvement should there be in the trust. And we talked about these complexities. Remember, in most trusts, there's no court oversight. Family relationships are a factor. Conflicts of interest could be a factor. Knowledge and experience could be a factor. And last but not least, what I kept alluding to earlier, the willingness or ability of the trustee to serve, to actually serve, is a factor. And for those reasons, we want to include flexibility in the planning. Some of the tools we use for flexibility in modern planning have to do with advisory committees. Depending on the situation of your loved one and their health situation, their mental health situation, a trust advisory committee could be a very powerful tool. But I'm going to strongly recommend that the trust protector, or what Maryland calls the trust advisor since 2014, this is a flexibility tool. This is a special fiduciary that you can appoint in your trust. And this special fiduciary has certain powers. Powers to remove trustees, power to replace trustees, power to review accountings, power to make changes. Imagine that you were a person who passed away, and now 20 years after your passing, your loved one is continuing to live. They have the special needs trust, the supplemental needs trust, and that trust needs to be changed. And most assuredly and most certainly, that trust will need to be changed in the future. For example, we will talk about the Secure Act here in just a minute and how it affects retirement plans for people with special needs and people across the board. But just for example, in the last 3 years, the Secure Act has changed at least twice since President Trump signed that in 2019, and both sides of Congress agreed. And now we have some very onerous rules for people who receive retirement plan benefits, except that people with chronic illnesses, people with disabilities are exempt. So we need to understand that. And we want to have trust protector flexibility to be able to make future amendments to the trust. Now, with that said, there are those of you who will not be able to get comfortable with this idea of the trust protector, and I want you to know that is perfectly fine. But the vast majority of our clients are comfortable with this flexibility idea that you will appoint not only trustees, but you will appoint trust protectors who will have certain powers to direct the trustee and provide flexibility to the trust in the future. Now, planning is always changing. I was talking to a family lawyer the other day who said, Steve, you just wouldn't believe the changes constantly in family law. And elder law and special needs planning is no different. There are constant changes and updates. So right now, this is what I would say represents kind of a visual picture of what I would call a third-party trust. And this third-party trust would have trustees. We would have trust protectors as we go kind of counterclockwise here. This trust would have Maryland Able, achieving a better life experience powers. It would also have an advocate provision. Now, why do we include all these when in the past, attorneys would not necessarily include all of these things? Well, not only does content change and approaches change, but the style changes. So in my opinion, this particular style calls out the trustee to remind them, this is what you should be thinking about. You should read the trust and you should understand the powers that you have and the flexibility you have to do what? Well, initially we said that the purpose of special needs planning was your special purposes, your special goals, but it really was to create a world, a flexibility infused world of support for the person. So this provides that kind of high-level support with various features, advocates, memorandums of intent, a trust advisory committee, and notice special retirement plan provisions due to the Secure Act and the fact that people with disabilities are exempt from the Secure Act. And we want to make sure that not only are they exempt, but their trusts are exempt. And that means advantages for the stretch out of retirement plan taxation. Now, trying to be a little bit humorous in this very serious subject, Jeff looked high and low and he found these particular people. I don't think we've named these people yet, Jeff, or you're not revealing their names, but these are perfect people. And of course, I'm being a little bit facetious, but these are our perfect trustees. And you see that they do all of these things. They advocate, they are accountable, they understand financial aspects of planning. Now, let's say they're great advocates. These are great people. They understand your loved one. They know them, and they're going to advocate for them, not only because they know them or they get to know them, but because they are understanding that a person with disabilities has to have advocacy for what is in their best interest, understanding public benefits, promoting their life and their interests, making sure there's communication. Now, looking down there at accountability, this person understands intuitively that they have to keep accurate records. They understand that they have fiduciary responsibility, and no matter what the person's level of capacity, they should be keeping them informed to whatever degree that may be possible, or their representatives or supported decision makers. And in the financial concentric circle here, we see that they, at least on a fundamental level, understand investing. But do they have to understand all of that themselves? Do they have to be professionals? And the answer is no. If it's a non-professional, they at least understand that they can hire professionals. And that is the biggest thing I would say you will find in a trustee is if it's a non-professional trustee, We want them to have an elemental understanding so that they will hire professionals, and the trust says they can hire professionals to carry out their professional duties. Now, what can a special needs or supplemental needs trust pay for? This is going to depend on the definition. A supplemental needs trust, by definition, is this third-party trust that you or your family creates to support the loved one with disabilities. That trust can be quite broad, and basically anything for the benefit of the beneficiary is going to be acceptable within reason. A special needs trust is technically a first-party trust. That's the one where the loved one came into possession of money they shouldn't have had, and it was put into a first-party trust. Now, that trust is more restricted. That trust has to be for the sole benefit of the beneficiary, and there's an accounting that's required. But what you would find is even that kind of trust is quite broad on what can be spent for the benefit of the beneficiary. So that's a subject that we could discuss in one-on-one counseling. We talked about how much to fund a special needs trust, or a supplemental needs trust, I should say. And life insurance is going to be a funding tool. Retirement plan assets are a funding tool. We want you to work this out with your financial advisor, or if you don't have an individual financial advisor, we would like to help you find one or connect with one. Many of you may invest with big wirehouses such as Fidelity or Schwab or Vanguard, and your financial advisors there should be helping you project and to really understand how much should you fund. Many of you will leave equal shares for your special needs loved one. Many of you will leave unequal shares. You will give your special needs loved one more or less than the other children, depending on the makeup of your assets and what you're going to be using as a funding tool. We talked about the first party trust. In the interest of time, I'm not going to go through this again. This is the mechanism that allows us to maintain public benefits under federal and state law. This could be a personal injury award, or someone has received an inheritance. If they, even if they did not intend to receive it, they received it. So we want to plan and understand that a first party trust may be necessary. And this reminds us that when we are doing basic planning through a third party trust, we want to educate family members on the outside that if they are leaving assets for our loved one, that those assets are left in their proper way to the third party trust. Let's talk about what it takes to establish a special needs trust. Now, this is our kind of funny chart. We're trying to show the energy here of our meetings, and we are educating clients. So at Elville & Associates, we educate clients just like we're educating today and giving you some substance to take away. This process is really a process of review. This is a process of giving you time to think. And as you take a look at this kind of funny looking chart, you'll see in the middle there, we are strongly recommending that you have an advisory team. But if you don't, we're going to help you form one to whatever extent you would like one. And we want to make sure that we're getting advice at the highest level as we think through all of these issues. This is kind of a narrative summary of our process of education. Touching on guardianship again, this guardianship is the most restrictive alternative. So we want to think about, does our loved one need a guardianship? We're kind of coming, let's say, to a planning point in our lives where we're going to be thinking about the planning. A lot of these issues, such as waiver programs, SSI, guardianship versus no guardianship, all of these things kind of converge many times at the same time that a family is thinking about planning. There are two types of guardianship: guardianship of the person, guardianship of the property or the estate. These are nuance issues, and we usually cover these in planning consultations about special needs planning. The supported decision-making legislation was a big issue, a big triumph for Maryland to finally get behind this legislation when our neighbors in Delaware and in DC and in Wisconsin and Indiana and Alaska, Texas, and about 20 to 22 states now have this. We won't spend a lot of time on it today in the interest of time again, but I encourage you to read our article on supported decision making and to look at other articles and videos on it and wrestle with this issue for yourself, because it's not an easy, it's a simple issue in a way, but it is not easy to decide about for some people. Some parents are very and relatives are very much excited about it. Some people are skeptical about it as a utopian concept. But as we think about supported decision making, I want you to look at these slides and just kind of start to get your mind around it. Look at our article that Jeff will send out, and I'll tell you what the concept is in a simple way. To me, the concept is this. I, as a person with some disability, whether it's big or small, I have the right to make my own decisions. So now the law recognizes that more and more in a bigger way. But I will make my own decisions to whatever extent possible, provided that I have someone who will support me. If I have someone who is my supporter, I will make my own decisions to whatever extent possible. That is the simple supported decision-making concept. But on a graph or on a continuum, I guess, of how disabled or non-disabled someone is, or the extent or type of their disabilities, this may or may not make sense. But what I want you to take away from this simple explanation is the law finally recognizes the rights of your loved one with disabilities in a much greater way, coming down from a United Nations mandate on human rights. So this is a broad subject. We'll move on, but I want you to get your minds around that. So in making decisions about the future, I want you to think in terms of this memorandum of intent. If you don't do it, it's not the end of the world. But if you do it, this memorandum is something that you can keep up with throughout the rest of your life and the life of your loved one. And this is a creative tool that you can use with your special needs trust. Establish the estate plan, of course, not only for your loved one with disabilities, but for yourself. We don't have time to get into this today, but in many respects, the estate plan that you create for yourself is in essence not only protecting you, let's say, during life in the event of an incapacity, but it's also protecting your loved one with disabilities because of your roadmap that you've put in place for yourself. And that's something that we can further explore if you were to meet with us. Establish the special needs trust. That trust is going to stand on its own most of the time. That is a separate trust. It's a tool that's used. Or in some instances, that trust is going to live right inside of your documents themselves and not stand on its own. But in a preferred way and for longevity, that trust will stand on its own. And we're going to calculate your financial needs through the planning team. And we're also going to name the special needs trust as retirement plan beneficiary on certain retirement plans that you may have. And there are special considerations under the Secure Act. So we strongly encourage you to understand public benefits, to continue to educate yourselves in the way that you did today. Make plans for the future based on this continuing education. Start thinking about those persons who will be your advocates. Introduce your loved one with disabilities to advocates, and we can work with you to do that if you do not have an advocate in mind, and to make special needs, of course, part of the fabric of your own estate plan. So someone once said to me, well, Steve, you know, Elville and Associates does a great job of educating, and we take pride in that, and we hope you've benefited from that today. But this person also said to me, who was a very high-level financial advisor, said, Steve, we should also make sure people have a path forward and people can organize this path forward. So that's really our goal. So we want you to know that we're here to set an appointment with you. We do not charge for initial consultations. We strongly encourage you to complete an estate planning questionnaire. The questionnaire has a lot of personal information, and this gets to the issue of, well, can I relax and can I share information with a complete stranger, someone I don't know, but someone who I might want to have a relationship with? So I want to kind of frame that for you. There is really nothing to fear there, and I'll tell you why. If you're willing to share your information with us or your thoughts or your feelings with us in a private setting, all attorneys, especially special needs planners and estate planners, there is an attorney-client relationship when you do that. So when you come and speak to someone like me or the attorneys here at Elville and Associates, you are forming an attorney-client relationship with us, even if you don't become a client, even if you don't move forward. So we are bound by the ethical rules. We are bound by confidentiality. So when you think about it, there is nothing to fear, and we want you to relax. For those of you who have estate planning documents, we want you to bring those, even if you don't have a special needs trust in place, but you have estate planning documents in place, we want you to bring those and we will review those. And generally speaking, we do not charge for the review of your current documents. As I've mentioned several times, we want to help you form an advisory team. We're big believers in this. This is not required, but it certainly is something that I hope that we could educate you about so that we could help you. And many of you do have an advisory team in place, and we want to meet those advisors, and we also want to collaborate with them and speak with them and make sure that they're speaking to each other. We're almost finished, I promise, but we also want to see questions or concerns that you may have. So we really like your questions. Thank you for your questions today. We will review your list of questions. We will juxtapose those questions with the ideas and the contemporary options that are available to you, and address things that have been bothering you perhaps for many years. We also want to give you the time to think. We talked about that earlier, and we see that as one of our biggest missions here at Elville and Associates that we can do for families with loved ones with disabilities, is give them the time to think, work with their advisors, help them develop advisors if they don't have any, and help you develop what your goals are. Some of you know what those goals are, some of you do not. And in the planning process, I almost promise for sure, not 100%, but there's a very, very strong possibility you will have an epiphany of what your goals are. And so that's what I encourage you to do, and to relax. Jeff, I'm going to turn it over to you, and I just want to thank everyone today for your time and attention on this Friday morning. I wish you a great weekend. And Jeff, I think we have about 10 minutes to spare, so we're pretty much on time, and I thank everyone again. Jeff, I don't hear you, but I assume that you're there. And
I'm so sorry. Yeah, I was talking to myself there. I'll start again. Thank you, Steve, for a great presentation. Lots of great education and important information to share as always. And as I always say, now would be your time to get your final questions into Steve. We do have some questions here I'd like to pass along to you, Steve, without further ado here. Some good ones here. And I'll go ahead and get them over to you here. So our first question here is, can you roll assets from a living trust into a third-party trust?
Thank you for that really great question. And just right off the top of my head, I'm going to say yes, because a third-party trust can be revocable. And remember that a revocable trust is a grantor trust. You are the owner of a third-party trust. You're also the owner of a revocable living trust. And both of those would be, if the special needs or supplemental needs trust was revocable, both of those trusts are identified by your Social Security number. So there's no problem at all. If you say rollover, I'm assuming you mean take money out of this trust and put it into this trust. There's absolutely no difference tax-wise or anything unless you sold assets and liquidated assets, of course, and you might have capital gains on those sold or assets. But if you simply were to retitle assets from this trust into this one, if they were both grantor trusts, both revocable, there would be no difference.
Okay. Next one is, if you were to create your special needs trusts in one state and then move to another state, do the documents need to be redone in the new state?
Excellent question. Thank you. The answer would be yes. It would be advisable to do that. Now, there's no requirement that you do it, but it would be advisable. And I'll give you an example, and it has to do with Washington State. And I don't know why, but I have had a lot of experience in the last 10 years with people moving from Maryland to Washington State, among other states. And if you were to establish a third-party trust in Maryland for your child or loved one, and you move to Washington State or any state such as Washington State, and let's say your loved one moves with you, which I'm assuming they would, then it would be advisable to change the state law and the situs or the location of that trust to the new state. And most states, or a lot of states, have their own what I would call discretionary trust acts. So when you make that move, it would be a matter of maybe restating, and that's why it would be good to have a trust protector, or if it's a revocable supplemental needs trust that's unfunded, you could simply just redo it yourself or restate it yourself. But I do think that that would be a very advisable thing to do.
Okay, thank you. Next question is, how do we name or get trust protectors and advisory committees when there are few friends and family members available?
Thank you for that. And that gets to the issue of thinking through these issues, just like you're trying to do right now. And I really thank you for that question. Um, Everything is nuanced in planning today. And, there's a lot of forces at work. Jeff and I were just talking about some of them this morning, societal forces. There are sometimes relatives, sometimes there's no relatives available, or people that we can trust. So what we try to do in the thinking process and the counseling process is think through ways that we can stopgap these things. Perhaps there are going to be social workers or a psychiatrist or family physicians, and we can name those kinds of people as potential participants in the trust advisory committee. So this is going to be fluid in some cases. So we use our imaginations. Now with trust protectors, we can use family members, and you had stated there's not really family members available. There might be a friend at church who might know your loved one with disabilities, a friend from work, someone who has personal knowledge of what's happening, more or less, and that person might be a good trust protector. Or it could be your attorneys, or it could be your CPA or an independent person like that. So usually a trust protector is an independent person. Sometimes the trend today is to have family members as trust protectors, even though that kind of flies in the face of traditional trust protector planning. But in special needs, sometimes family members are trust protectors. In your case, there aren't any family members or friends that are suitable. So I would say you're going to be evaluating your attorneys and CPAs and other professionals as a trust protector.
Okay, thank you. Next, I'm court-appointed legal guardian for person and property for my 20-year-old nephew who is severely incapacitated with developmental disabilities and is nonverbal. What documents or information would I need to bring along to a consultation interested in special needs trust and financial planning?
Thank you very much. Well, I want you to feel that you don't have to bring a lot with you, but if you are inclined to want to bring something with you and you have that information available, we would like to see any estate planning documents that you currently have, if you have any, including powers of attorney and advance directives. We would like to see you complete a questionnaire, if you're so inclined, to give us some preliminary information about you, personal information versus financial information, and whatever you're comfortable sharing. We would also like to see a copy of the guardianship order for your nephew. So those things, I think, are more than enough, along with whatever specific questions that you may have, and that would be more than enough for the initial visit. So thank you for that.
Okay, next, do you work with special needs attorneys in Virginia?
Thank you. Yes, the answer is yes. There are some great elder law attorneys in Virginia. And if you could let us know where you are located or where your loved one is located, whether it's Northern Virginia or the Northern Neck or wherever it may be, we can help you get connected with someone.
Okay. Our daughter with special needs is currently 5 years old. At this point, it's difficult to predict how independent she will be upon turning 18. Would you recommend starting a special needs trust at this stage? Thank you.
Thank you. Thank you for that. And I'm just going to answer that by saying I don't know the extent of your daughter's disabilities, and only you know that. And we know just from your question that The extent of those disabilities or what she will or will not be able to do may be a question right now. We just really don't know, let's say. So what you can do as a parent is you certainly should do, if you are knowledgeable enough or convicted enough, I should say, in your belief about what you know about your daughter, to the extent that you say, well, if I were to die today, I would treat my daughter, so to speak, as a special needs beneficiary. If you know enough information from doctors and your experience that right now you consider your child to be a special needs beneficiary for your estate planning, then I would go ahead and do special needs planning. If you are not convinced that your child may be special needs, but you have suspicions that they are borderline, you could treat her as a general needs beneficiary, and we could install what I would call a standby supplemental needs trust in your documents, where even if you never did any other planning, you would allow for the possibility of your child to be treated as a special needs beneficiary, even if you don't do that now. So we can build flexibility into the planning, but we need to take a really solid look at where is your belief right now about her situation as a special needs beneficiary versus a general needs beneficiary. And if you do special needs planning now, remember that that planning can always be changed. Nothing is written in stone. That's a trap that a lot of us fall into, is we think that if we're doing planning now, and it's a big thing, that we are so invested in it that we tend as human beings to think this is forever. But if you do the planning with the idea that the planning evolves over time, it is not a transaction. This is an evolving thing, just like the memorandum of intent is an evolving thing over lifetime. Now we release ourselves from that being locked into something, and we can always change it. That's a great question.
Thank you. And we have one more here, a couple of comments though. Thank you so much as always for a great presentation, Steve. A belated happy birthday, Steve. My daughter with special needs celebrated her birthday last Saturday as well.
Oh, thank you. Thank you. Congratulations. Thank you.
And a question from one of our good financial advisor friends, Chris. Jeff, question for Steve. What housing resources exist for families that have a loved one with special needs regarding housing? We are a family with sufficient means. Our loved one lives at home now, but as parents age, that may not be an option, or when the parents pass, something like a senior living or assisted living facility might be a perfect option for this person with special needs, but she isn't a senior yet. Any thoughts?
Chris, thank you for that question. I hope all is well with you. That is a very challenging question that I'm going to admit from the outset I don't have a complete answer to. This is going to depend on the location with the county and the location. It's going to depend on whether that relative is in the waiver system, the DDA system or other waiver system, and whether they have housing supports because they were disabled prior to a certain age, and they also got into the system on time. So that's going to kind of determine a lot of that. The other issue is really going to wrap around the age, which you mentioned, and it's also going to talk about or consider the possibility of mental health issues versus just developmental or other disability issues. And if I'm suspicioning from the nature of your question, if this person is kind of a person that is in between and falls through the cracks, that's very difficult when we think about the fact that, as you mentioned, they are not elderly, they're not aged, and yet they might be best suited to live in assisted living. So there are programs out there, depending on the level of financial support that's available for this person. And you mentioned that there is sufficient means available. So there are day programs and support programs that also include housing. Those sometimes are stopgap measures that really work well versus this person having to live someplace that's not appropriate for them. So I think if we could circle back with kind of the lay of the land regarding the person themselves and all of those factors that I just mentioned, then we could be more specific about what might be a good solution in the future. But there are programs out there, depending on what the disabilities are, that are these stopgap places places, I should say, or housing solutions for that kind of person. But again, it's going to depend on the facts.
Okay. And thank you for that, Steve. We do have one more, and then we'll wrap up here. It's 11:30. Thank you for the information. First of all, I'm having 2 sons, and both were diagnosed with autism. You once mentioned about dividing the trust into different children, equal or not equal, while they are both too young now, 4.5 and 3.5. What is your advice for me regarding establishing the trust for both of them? Thank you.
Thank you. And I'll say very briefly here, because we're ending, that's a great question. I would say you're going to develop 2 separate supplemental needs trusts. So Maryland law seems to, in my opinion, speak to a supplemental needs trust really being for the benefit of one person. So first of all, there would be a separate, in my opinion, supplemental needs trust for each child. And when you are doing your own basic estate planning, your will or your revocable trust that eventually funds these special needs trusts or supplemental needs trusts, you're probably going to leave equal shares from just what I've heard here. Of course, this is personal to you, but both of those children have disabilities, they have autism. And so I think 9 times out of 10, you would be thinking in terms of equal shares, unless there was a strong reason not to leave equal shares, but you would be leaving those shares to separate supplemental needs trusts, and that's not hard to do. So it's a great question, and very, very much wish you the best of luck in raising those 2 kids.
Yeah. Well, very good. Well, thank you for being part of our webinar series, as always. As Steve said, planning evolves over time. The hardest part is getting started. Let us know how we can help. As always, I send out a comprehensive message afterwards with a lot of information, and I'll be doing that for you as part of my follow-up for you, including everything and more that Steve talked about. And I'll also include our calendar for our upcoming webinars. We have a lot of really interesting ones, including Maryland Able will be coming back to see us in September, and I'll have some information about that and more. So look forward to seeing you again soon on the Elville webinar series. Have a nice Friday and a great weekend. We'll see you again soon. Thanks very much.